Hello and welcome to round two. If you were on a few seconds ago, we're going to start again. This is Disability in DC Metro's September webinar, Focus on Disability, What All Employers Can Learn from OFCCP Section 503, featuring Lynn Clements, Esquire, Director of Regulatory Affairs at Berkshire Associates. I'm Catherine McCary, and as you can see, I'm the CEO of the DC Metro chapter and a few more titles. The DC Metro chapter of Disability In is a nonprofit business-led network whose purpose is to engage employers in a dialogue through education and resources with a focus on removing attitudinal and organizational barriers by exchanging best practices to ensure that talent with disabilities are included, retained, and promoted in today's workforce. Please do sign up for our newsletter at didcmetro.org, where you will see all the events and articles of interest. The session is being recorded and captioned. Each attendee will receive a copy of the session. You're asked to please mute yourself. Use the chat feature to ask Lynn a question, who will answer as many questions as she has time for. So let me begin by introducing Lynn. Lynn is the Director of Regulatory Affairs and oversees Berkshire's audit defense practice and has helped clients defend hundreds of OFCCP compliance reviews, including nearly 50 Section 503 focused reviews since 2019. Previously, Lynn served in the several senior level positions at OFCCP and EEOC, and as a shareholder at a management side law firm where she advised clients on the full range of employment issues, including large-scale class discrimination investigations. Lynn's testified before Congress on EEO and pay equity issues and regularly assists industry organizations, including SHRM, Society for Human Resource Management, and CUPA.HR, in understanding and responding to regulatory proposals. She's currently Secretary for the Baltimore Industry Liaison Group, a member of the Advisory Board of the National Industry Liaison Group, and a faculty member at the Institute of Corporate Equality. Lynn graduated summa cum laude from Wilkes University and earned her Juris Doctorate cum laude from Georgetown University. I've known Lynn for several years, and we've actually co-presented off and on through the years. I regard her as a friend and a valued thought leader. Welcome, Lynn.
Catherine, thank you so much for that wonderful introduction. And I want to thank everyone for joining us today. I know as HR and compliance leaders, your plates are full right now as we deal with the impact of the health pandemic on our workforces. So I really appreciate you taking the time today to join us. I'm going to talk a little bit today about what all employers can learn from OFCCP's focus on disability inclusion through its Section 503 reviews. I wouldn't be a lawyer if I didn't mention, we are going to try to give you practical tips today, but the facts matter, particularly with respect to ADA issues. And so before you implement any strategies, you want to talk with your dedicated consultant or legal counsel, just to make sure that it makes sense for your organization. Just a little bit about Berkshire on the next slide. For those of you who are not familiar with Berkshire, we work primarily in the affirmative action space. Catherine, if you could move to the next slide, that would be great. I would appreciate it. I don't think I'm able to do that. So as I was saying, Berkshire is an affirmative action expert. We've really been doing this work for 35 years, if not longer. And one of my particular passions is actually disability inclusion and compliance. And so personally, on a personal level, I have been really pleased to see the government, and in particular OFCCP, use its enforcement authority to bring attention to these issues. Okay, so next slide. Looks like we've lost the slides. So I'll give Catherine a minute.
Yep, I don't know exactly why that is, but hang on.
Okay. So that I was joking with Catherine as we were preparing for this meeting that I think one of the things the health pandemic has done for all of us is teach us to be technologically flexible, is what I like to call it. So this doesn't always work, and I appreciate you being patient as we figure out these new technologies. I do think in a strange way, the pandemic actually provides real opportunities for organizations to make huge strides in terms of disability inclusion, right? Because companies are learning that work can be done in different ways. I think to the extent there was skepticism before about certain things working or being effective, I think we're learning during this challenging time that there are lots of different ways to do work. And that may end up being a huge positive for individuals with disabilities. So I think we're experiencing one of those examples right now. I'm hopeful that Catherine can get the PowerPoint back up. If not,
I think so.
Yep, we see it now, Catherine. Thank you.
Oh.
There we go. Perfect. So we can actually move on to the next slide. I want to be mindful of everyone's time. Since it took us a little bit of time to get started, I'll just jump right in. And I want to talk a little bit about just OFCCP's broad focus on disability inclusion. I do want to point out that the government has made some terrific resources available online, and I really encourage you to spend some time looking at OFCCP's website on this issue. On some level, OFCCP's approach to highlighting disability inclusion is actually a really great case study for organizations who want to make strides in this area. The reason I say that is because this initiative at OFCCP really came because of passion from the top. OFCCP Director Craig Lynn really understands the challenges that individuals with disabilities face. He has 2 children who he has openly talked about their disabilities and the challenges that they have faced. And he also knows what it feels like to request accommodation for his children and how difficult sometimes that can be to go through that process. And he had a real commitment as the top leader at OFCCP about changing this. And I think that is really actually a terrific approach, a terrific takeaway for every organization to understand. If you want to move the needle on this issue, you need to have a high-level official champion. It makes a world of difference in terms of whether and how much change you're going to be able to make at your organization. So one of the first things he did was actually put out a message to his staff about the importance of disability inclusion and his commitment to this issue. It's available on OFCCP's website. You can find it by going to the link here. This is not the direct link, so you may need to look a little bit, but that's a great tip. If you can have a top-level official message your employees about the importance of disability inclusion and your interest as a company in ensuring that everyone can bring their whole self to work, that has made a significant difference from what we can tell in whether an organization is able to move the needle. The other thing Director Lynn did is he prioritized this issue at OFCCP. So after he said this was important and I want to make a difference, he took action. And the action he took was to schedule a new type of review for federal contractors. It's called a Section 503 focused review. The first time these reviews appeared in OFCCP's scheduling list of audits for contractors was in March 2019. There were 500 of these reviews scheduled. And as Catherine said, Berkshire, my company, has actually helped about 50 clients or so go through these reviews, including on-site visits visits by the government to look at accessibility and inclusion practices. This has been all across the country. It's been a wide range of clients, small clients, big clients, various industries. And one of the things that we have really learned some big picture takeaways that I'm going to share with you today. Some things that I think all employers can focus on and learn from these reviews. I will say that Director Lynn is also continuing the focus. And so a new scheduling list was actually just released last Friday, and there will be additional 503 focused reviews. So more employers will be subject to these reviews by the government if you're a federal contractor. These reviews really sort of focus on your 503 affirmative action plan. If you're a federal contractor, that's the AAP you prepare for individuals with disabilities. But they also are looking at things like, how do you handle accommodation requests? Things like, what kind of outreach do you do towards individuals with disabilities? How do you ensure that individuals with disabilities, once they enter your workforce, feel included and remain in your workforce? So retention issues. The agency also scheduled another new type of review. So they're called accommodations-focused reviews. They are on the new list that was just released. And I think this really further emphasizes Director Lynn's belief, that one way you move the needle is really from an enforcement perspective, to focus on an issue in depth, because that just naturally has the effect of having the employer community, the regulated community, focus on the issue as well. We don't know a lot yet about these accommodations focused reviews, so there isn't a scheduling letter yet. We don't know exactly what OFCCP is going to ask in these reviews, but we believe, based on what we've heard, that they are going to focus on how employers manage the accommodation process, not just for individuals with disabilities, but also accommodations related to religious beliefs, because there is a companion requirement under the law to provide accommodations due to sincerely held religious beliefs. So there's more to come on that. I raised this on this call, though, just to say, I really think if a company takes a step back and looks at what Director Lynn did with his organization in terms of telling them this issue was important to him through a message, reinforcing that this issue was important by taking action, and very concrete action for his agency, that's kind of a good roadmap for a private employer to use who wants to move the needle in this area within their organization. So obviously your action items are going to be different. You're not going to schedule reviews necessarily, although we have had a few clients who aren't on the list conduct mock audits. And that has been a very effective tool. So I think there's a lot to be learned from just how Director Lynn at OFCCP has implemented this initiative. I did also want to mention on the next slide, just a housekeeping matter, because this is a change. So if you are a federal contractor, I wanted to remind you that there is a revised self-identification form, and that was approved in the spring, and you are to be implementing it. You were to have it implemented by August 4th of 2020. And so, Catherine, if we could just advance to the next slide. Doesn't seem like the slides are advancing, Catherine.
Well, I have advanced them.
It's possible that you have to share your screen again. So sometime I have found Teams a little bit tricky when it comes to PowerPoint presentation. So if you haven't shared your desktop, every time you advance the slides, there may be a little bit of a problem here. So let's see if we can just get back to the slides and then we'll keep going.
Okay, let me see.
And I do see some folks on camera, so I'm actually going to turn my camera on too. Hi, Cynthia, I can see you. You know, Catherine and I talked about whether we were going to use camera or not, and we had said we probably wouldn't, but I kind of like it. This is one of the new things about working the way we're working right now. And so I'm going to turn on my camera unless we start having technical difficulties in terms of lag time. I do have a fake background behind me because I have a daughter who is in school and a cat who likes to sit on my lap. And so hopefully you won't see any of that. The other housekeeping thing that I wanted to mention, actually, we're not going to talk about this today because this could be a whole webinar, if not more than one webinar. But I do want to highlight that the government has put out some terrific resources on the impact of the health pandemic on your ADA obligations, your ADA and EEO obligations. And so if you're interested in those issues, these two links will take you to the Department of Labor's OFCCP information, and then the bottom link will take you to EEOC's information. You know, it is kind of interesting, to be honest, just the timing of all this. Like, who would have thought that Director Lynn would decide to focus on disability inclusion, and then just a short time later, we would be in a health pandemic? And, you know, the health pandemic, in a strange way, has kind of given compliance professionals an added reason why this should be important in your organization, right? And while none of us want a health pandemic, I think it's important, if you're a compliance professional, to realize that this is an opportunity. You have the attention of your leadership on this issue. And sometimes that's what you need in order to make a difference in this area. So let's go to the next slide and talk just briefly about what an OFCCP compliance review looks like right now. So OFCCP is also working remotely, and I think they will be for the foreseeable future. So for you, those of you who are federal contractors, and I think we have a good mix on this call, so I don't want to spend too much time focusing on what it looks like in an OFCCP audit, but I do want to mention some things. You know, one of the things, another initiative that Director Lynn has really pushed forward is a transparency initiative, encouraging the agency to be more transparent about what it's finding in compliance reviews, what its concerns are, what its questions are. I really hope that that continues. It has been very refreshing to have a better lens into what the OFCCP and the government is concerned about, what they're interested in knowing more about. And I think it's been helpful to contractors. One of the results of this transparency initiative that I'm super excited about is that at the end of these 503 reviews, Director Lynn has indicated that the agency is going to be putting out an annual report of some type, and he's going to be publishing in an anonymous way best practices that they have found during these reviews, as well as some not so great practices that he would like employers to change or to take a look at. And so I want to highlight that for all of you, because that's a document that I think we're all going to want to read. I think the agency has done a really nice job with its resources in this area, and the push to be more transparent, I think, is actually just really helping employers move the needle, because we have a much better understanding of what the government is concerned about, what their areas, pain points are, so to speak, and that allows you to target where you need to make improvements. The other thing I would say is that a lot of these Section 503 focused reviews are, they all include an on-site visit. These on-site visits have been virtual during the pandemic, and I think one of the things the agency has learned is that the virtual environment actually is pretty effective for them. And so I think we will see the agency, even after the health pandemic, continue to do some of its work, quote unquote, virtually. And what I mean by that is I think you will see the agency conduct on-sites through Teams meetings, just like the one we're on, you know, not necessarily physically coming on site. I think that's helpful for contractors as well as the agency because it makes the process a little more efficient, a little less intimidating on some level. And so I think there have been some real positive changes in the way OFCCP is approaching compliance reviews, particularly in light of the virtual environment we're all in. We can go to the next slide. And now we're really going to get into the heart of what we want to talk about today. So what have we learned from all of these focused reviews that OFCCP has been conducting? I think this slide is a pull out of the slide deck slide and use as a checklist. These are the things that we have consistently been seeing OFCCP focus on during these focused reviews. So they are interested in understanding accessibility. In particular, looking at entrances to building. Are there ramps? Are there the push buttons? How do individuals access restrooms, bathrooms? You know, I realize that some of the answers to these questions depend on standards, accessibility standards that are enforced by the Department of Justice. But I will tell you that when we are preparing clients for these Section 503 reviews, this is one of the areas where a lot of our clients are having an aha moment. You know, I just spoke to a client the other day and he said, you know, we're preparing to take those photos we need to take to show that we have a handicapped restroom or an accessible bathroom. And I just realized that you cannot reach the paper towel holder if you're in a wheelchair. And I don't know what to do about it. And, you know, so we had a really great discussion about that. And it sounds really small, but if you're an individual with a disability, you know, something like that is the difference sometimes between whether you feel like your employer is really welcoming of individuals with disabilities or is only paying lip service to it. And some of these issues are easy to change. You know, we talked about a way that this employer could change that immediately without having to move the paper towel dispenser, you know, down necessarily. What are the other ways that you could make sure someone was able to wash their hands and dry them in a restroom? So that's one area that OFCCP has been focusing on, and one area where surprisingly, I've had a lot of really great conversations with employers about this issue. Like, why don't we have buttons to our bathrooms? Or, oh my goodness, I realized our suite is locked. And if you're an individual in a wheelchair, I don't know how they've been managing to go to the restrooms without having to ask someone else. And so these are great conversations and ways, I think, something that all employers can look at. Some of the, sometimes you're not going to be able to fix all of these issues, especially if you don't own the building. You may need to work with your landlord to address some of them. Some of them may not be required, depending on the accessibility standards that apply to your building, but could be best practices that you talk to your landlord about. The other thing the agency has been looking at in these reviews is, are you placing all of the required employment notices up? And, this is the bulletin board. It's kind of weird to talk about a bulletin board when we're in a virtual environment. Probably no one is working in the office, or very few people are working in offices right now. But the agency is checking to make sure that you are providing the required employment notices to employees and applicants. I would say as a best practice, I've learned two things from these focus reviews, two things that I like to highlight to employers. One, if you are posting on bulletin boards, you want to think about the height of the bulletin board for an individual in a wheelchair. Can they read all of the notices? We have found that sometimes when you look at your postings in that way, you realize there are some improvements you can make there. But two, and probably more importantly, is to think about the fact that most people or many people are not looking at bulletin boards anymore. Many of us are working remotely. For some of us, that may be permanent going forward. So you're never going to go into an office and look at a bulletin board. And so as the best practices that I've talked to clients about in this area and that we've seen OFCCP ask about is, do you have an intranet site? If you have an intranet site and you post other company policies there, these notices should be there too. Because it's so much easier to click online and see a policy or a notice than it is to go searching in your building for the bulletin board. The other thing I want to remind everyone is that these notices, some of them also have to be made available to applicants. And so a best practice takeaway for all employers, because this is true for non-federal contractors as well with some of these notices, is do you have them on your career website? It used to be that the applicants came into your building to apply. Maybe they filled out a paper application. For the most part, that's not happening anymore. We all use electronic applicant tracking systems, and folks are not coming into your building. And so posting these notices on your career page and demonstrating your commitment not just to disability inclusion, but EEO in general. So these notices include, just so we're all on the same page, this is the EEO is the law poster, the supplement, the EEO is the law supplement, which is required of most employers, not just federal contractors. There are some specific posters that federal contractors need to post, including some information about pay transparency, as well as employee rights under the National Labor Relations Act. And then there is also an obligation as a federal contractor to, and frankly for all employers, to make sure that you provide reasonable accommodations to individuals in your, if you do use an electronic application process. And so most federal contractors have created a reasonable accommodation notice that is put on their career page that tells applicants, if you can't use this system, here's how you can contact us and get an accommodation. I think that's a terrific, great practice for all employers, not just federal contractors. So that's what we've learned in the accessibility and sort of notice area. One of the other things that OFCCP has looked at pretty significantly during these reviews is a client's application process. And we're going to talk about this in a couple of additional slides, so I'm not going to spend too much time here. But thinking through your process, what questions are you asking? What are the screening points in your process? Can that be improved to provide better equal employment opportunity for individuals with disabilities? Another area that OFCCP has focused on during these 503 reviews is how employers are requesting disability self-identification information. So this is unique to federal contractors. Those of you who are not a federal contractor should not be asking applicants to voluntarily self-identify their disability status because that could be a violation of the ADA. Federal contractors, however, are in fact required to ask applicants to voluntarily self-identify their disability status using that form that I was talking about earlier. OFCCP has been very focused during these reviews on that process. How are you doing it? How are you ensuring that the information is maintained confidentially? Who has access to applicants' answers to these questions? You know, the regulations say it really should be limited access. And so as a best practice, it's a small group in HR or recruiting. It's not the managers, etc. It's kind of like the locked file cabinet example that we all used to think about, those files that only a handful of people in HR have access to. So they're really wanting to understand how you're maintaining and collecting the self-identification information. Another huge focus has been outreach. And I think there are some real strong best practices here. In terms of things that all employers could implement. And one that I want to point out in particular is a lot of our clients have created employee resource groups that focus on either employees with disabilities, or a lot of times the groups are a little bit broader than that. And they're open to employees who may have family members with disabilities. And that has been something that I think OFCCP has determined is a very effective way to create an inclusive culture in your organization. So that's something I want to highlight as a best practice that we have definitely seen OFCCP asking about during these focus reviews. And something that I think all employers could fairly easily implement at not a significant cost, especially if you have other employee resource groups. So a lot of times when we first talk to clients about this issue, they will say, oh, yes, we have employee resource groups. I would say until recently, it's been less common for an employer to say, and we have one for disabilities. So it's often, employers often have a minority-based employee resource group, often a veteran-based employee resource group, or a females, a women in engineering type of employee resource group. But I'm seeing a growing trend, I think, based on OFCCP's interest in this issue, in considering adding a disability-based ERG group. And I think that seems to me to be a practice that has helped to move the needle for some of our clients. There's also been a huge focus in the focused reviews on orientation and training. Really, the question for me is, how do employees know what your reasonable accommodation process is? How do they know how to ask for a reasonable accommodation? Have you told them? Do you have a written policy? Have you trained them? Do you tell them when they onboard? Those are all opportunities that I think all employers can learn from. Significant focus on your reasonable accommodation process, and also just in general on your leave and other disability related policies like short-term and long-term disability. In general, I think the agency wants to know, and I think this is a good question for HR and compliance to ask in their organization, what happens to an employee when they request leave, or when they leave work for a period of time due to a medical condition? This is where I think it's a good idea to trace the life cycle of an employee, and we'll talk about that in a few minutes. Does their career stall? Is their pay impacted? Do they suffer termination after these types of leaves more often than others? So those are the areas that I think OFCCP has been particularly interested in the focused reviews. We're going to go on to the next slide. I want to take a moment just to see if there are any chats. I don't see anything, so I'm going to keep going. I did also want to do a time check. So we only technically have about 15 minutes, but we did start a little bit late. So if it's okay with everyone, due to the technical difficulties, I'm going to keep going. It may be that we end up going a little bit past 1:30, so I hope you all can remain. And if you do have questions, I do encourage you to type them in that chat box. I am trying to monitor it as best I can. In terms of who the agency has been talking to during these 503 focused reviews, pretty consistently, they've asked to talk to managers who are involved in talent acquisition, the reasonable accommodation process, those who administer your leave programs. To me, I say these first bullets are your internal team, right? So even if you're not subject to an audit, these are the individuals at your organization that play a role in advancing or impeding disability inclusion. And so if you're looking to change practices at your organization, these are the buckets of internal team members that you probably need to be talking to. OFCCP has also talked to employees during these Section 503 focused reviews. They often ask to talk to employees who have either requested accommodation, self-identified as being an individual with a disability, or took some type of leave, and in particular, parental leave or FMLA leave. Occasionally, they have also asked to talk to a handful of individuals who are not disabled, but that has been a little bit less typical in my experience. So for me, this bucket is the employees in your organization that you want to potentially trace their life cycle, right? What happens when someone voluntarily self-identifies as an individual with a disability? How long do they stay? Are they promoted? How does that compare to your average tenure rates, your average promotion rates? What happens when someone requests leave or accommodation? Is there some type of potential negative impact on their career that you want to monitor from a compliance perspective to make sure that it is not potential discrimination or as a result of requesting the accommodation or leave? Next slide. Catherine, oh, we did. Sorry, I was going to say, I don't think the slides advanced, but I think they did. Apologies. So I think there are a couple of good lessons really that all employers can take from this. And the one that I really want to spend some time talking about on this slide, really two things. One, if you are a federal contractor listening to this webinar, I just want to emphasize the importance of timely preparing your AAPs. OFCCP just last week released a proposal that will require all contractors to verify that they have established and maintained affirmative action plans on an annual basis. This will be under penalty of perjury or a False Claims Act claim potentially if finalized. And so you want to make sure that your organization will be able to submit this annual certification, right? And so just a reminder, affirmative action plans are to be prepared on an annual basis. There is also an obligation to sort of monitor progress throughout the year. So many of our clients also prepare a 6-month update. The other thing I wanted to mention on this slide is the importance of preparing an affirmative action program, not just an AAP with the data analytics in it. The regulations are really written to encourage contractors to analyze data as part of their affirmative action program, but then to once analyze that data to create a program or a plan of action. What are you going to do to address the data analytics you analyze? And this particular OFCCP has been very, very focused on that. And I heard Director Lynn on a conference call earlier this week, actually talk about the fact that part of his goal in bringing these conversations to light is that he believes federal contractors, sort of have heightened obligations in this area. That's the affirmative action requirement. It's not just meeting the basic legal requirements that apply to all employers, but going above and beyond. Granting accommodations whenever possible is the example he gave. And so I do think that's something that we're kind of consistently seeing in these 503 reviews. The other thing I think we're seeing, and this varies, I think, by employer, larger employers, I think, have more robust, centralized accommodation tracking processes. In fact, in many cases, the accommodation request process is outsourced along with leave management to a third-party vendor. But at smaller employers and even mid-size employers, I think we have discovered as a result of these 503 reviews that there's a real opportunity to rethink in most organizations how you provide accommodations. Is it, can you do it centrally? Is there a central budget that you can use in order to encourage managers to provide accommodations and not worry about cost? The other benefit of a centralized process is it allows for consistency, right? It also allows you to make sure from a compliance perspective that you don't have manager A saying no to certain requests and manager B saying yes, just because they're in different parts of the organization and have a different perspective. Now, there may be good reasons for manager A and manager B to have different answers, but when you do this process centrally, you have a central body sort of monitoring, right? When we're going to say yes, when we're going to say no. And I think that's hugely helpful. And it certainly is something that we've taken away from the Section 503 focused reviews. And then to continue on the next slide, there are some basic AAP requirements that I think actually all employers could benefit from thinking about. So these requirements right here are part of an affirmative action program. They're actually in the regulations. They are required if you're a federal contractor under Section 503. But the audit and the outreach assessment, as well as the personnel process review and mental and physical qualifications review, are things that I just want to spend a little bit of time talking about today. And I did see we actually had a question, so I want to try to address this. This is a great question. The question was, are all federal contractors, regardless of size, required to have an affirmative action plan? And the answer is no. There are both dollar thresholds as well as size requirements in terms of whether you have to prepare an AAP under OFCCP's regulations. But the size requirements are very small. So it is if you have 50 or more employees, you may need to prepare an AAP. So it's not just large employers who are required to prepare affirmative action plans. You do also need a covered contract or subcontract of a certain dollar value, ranging from $50,000 to $150,000, depending on the statute. But again, even the dollar thresholds for this requirement are pretty low. So most federal contractors do prepare and are required to prepare affirmative action plans. Great question. Let's move to the next slide. I want to talk just a little bit about this personnel process review requirement. Whenever I talk to clients about this, they sort of have this blank stare at first. What is a personnel process review? I don't think I'm doing this. What's going to happen if the government figures out I'm not doing this? And the first thing I say back is, I actually think you are doing this. You may just not realize, you may not be calling it a personnel process review, and you may not be documenting it. So a personnel process review is essentially what the regulations say is that federal contractors are supposed to review their employment processes periodically to determine if there are any barriers to employment for individuals with disabilities. This is an affirmative action obligation, but I think this is something that all employers can do as a best practice. And what are some examples? This is why I always tell clients, don't worry, I actually think you're doing this, you just may need to document it more robustly. If you have staff meetings about recruitment or outreach or turnover or succession planning, that's really a personnel process review, right? You're reviewing how your employment processes and potentially making changes and tweaks to how you're going to move forward. If you have an employee handbook and you update it each year, that's a personnel process review. You're making changes to your written policies and procedures. If you prepare an affirmative action plan each year, and you, as part of that, you're reviewing your personnel data activity, so your promotions, your terminations, your hiring activity, that is a personnel process review. You may be doing it on your own, or you may be doing it with a vendor like Berkshire. The other types of personnel process reviews that I think all contractors can focus on in this area are looking a little bit more at two areas in particular that I want to highlight, and the first is on the next slide. And I think this is a takeaway for all employers, even if you're not a federal contractor. A personnel process that many of you engage in is potentially medical exams or inquiries. So you, for example, might have pre-employment medical exams or some type of pre-employment form. You might have and by that I mean post-offer. So under the ADA, these types of exams all need to be done post-offer. That disability self-ID form that we talked about is technically a disability-related inquiry under the ADA, and so there are rules about keeping that information separate from other personnel files, limiting access. I just think in general, all employers would be well served to take a step back and take a fresh look at particularly any medical exams that are being administered, post-offer medical exams in particular, and how you're using that information and who's making those decisions. In the many years that I have been advising on this issue, I have come to the conclusion that many employers may be relying too heavily on doctors in this area. Not to say that relying on doctors and medical advice is not a good idea. It is a good idea, but you have to understand that under the ADA, the employment decision about whether you're going to bring that person on, whether you can accommodate whatever their disability might be, is yours as the employer. And what I have seen when I've worked with employers in this area is sometimes, you'll get back the post-offer employment form and the doctor says, oh, they have this condition, that's a high risk, they can't do this job. That may be true, and that may be a basis upon which to reject them, but there's probably a little more homework you should be doing as an employer under the ADA to make sure that you are using that information correctly, that you are considering whether accommodation could be made, that you are considering whether the condition or the screen is a qualification standard that you need to think about under the ADA. So this is a complicated area, and I think one really where all employers would be well served, this is a personnel process that I think all employers could take a fresh look at. Make sure you're doing it correctly. Make sure the timing is correct. You're only doing it post-offer after a bona fide offer of employment is made. And then most importantly, that you are using the information you obtain correctly and that you are fulfilling all of your obligations under the ADA to consider accommodation before you reject a candidate for employment. The other personnel process that I want to focus on, and this is really related to also the qualification review requirement and is talked about on the next slide, this is your application process. So as I mentioned earlier, a lot of you probably have an applicant tracking system. And you may be using pre-screening questions on your applicant tracking system. And those are questions that you ask of all applicants, right, to decide if they're qualified for the position. Those questions, depending on how they are written and what they ask about, can actually be considered medical inquiries potentially under the ADA. And so let me give you an example. If you have a pre-screening question that says, are you willing to work overtime? Or this job requires travel. Can you travel? Or this job requires lifting. Can you lift up to 50 pounds? Those questions potentially raise issues under the ADA. I'm not saying you can't ask them, but you want to be mindful about how you're asking them. And you also want to make sure that you're asking about things that are really required for the job. So my tips in this area are really twofold. One, it's how you ask them. I always encourage clients to ask these questions from a willingness to do the task, not a can you do the task. Just that slight change in language is more compliant with the ADA and makes it less likely that an enforcement agency is going to say you were asking a question that was likely to implicate ADA issues. So are you willing to travel 50% of the time versus are you able to travel 50% of the time? The second tip I always tell clients is think about reasonable accommodation language. So some of our clients have put at the beginning of their pre-screening questions, please answer these questions, keeping in mind that the company is willing to provide reasonable accommodation. Some of our clients have modified some of their questions to say something like, can you lift 50 pounds with or without accommodation? So this is a personnel process review area we have seen OFCCP focus on during these 503 reviews. Not as in a detailed way as I thought they might, but I think they're still learning themselves about these issues. And so for folks like me who have practiced in the ADA space like their entire career, I'm sort of a couple steps ahead of some of the compliance officers. But I think over time, this is an area that OFCCP may begin asking about in more detail, may start asking harder questions, may want to see all your screening questions and really begin evaluating, do these questions implicate the ADA and how are you using them? And are you using them to screen out individuals with disabilities? And if you are, that's a qualification standard under the ADA, and we're going to talk about that in the next slide. So there is a companion requirement to this requirement to review personnel processes to also review mental and physical job qualifications. I've reproduced what the regulations say as well as what OFCCP's scheduling letter says. And basically, as an affirmative action federal contractor, you are supposed to have a schedule for reviewing any physical and mental job qualifications. Non-federal contractors don't necessarily have to have a schedule, but it could be a best practice. But non-federal contractors have an obligation to make sure under the ADA, so not under Section 503, but under the ADA, to make sure that their qualification standards are job-related and consistent with business necessity. And the only way you can do that is to review them and review them fairly regularly. So I want to talk through, well, what is a qualification standard? And then I want to highlight one particular case that I actually think really brings home for employers how this issue can crop up more easily than you realize. So what are, first of all, qualifications? They're really, as EEOC has really defined them, as any kind of job requirement for a role. So they're things like education requirements, work experience requirements, certifications, certainly physical requirements like lifting, things of that nature. They're different from essential functions according to EEOC. Case law is a little bit murky on this, but according to EEOC, essential functions are what the employee is actually doing in the job. Qualification standards are supposed to predict whether the employee can perform the job, right? And that's sort of a distinction that's a little murky. It may not matter to most of us who are not lawyers and well steeped in ADA law, but it does become important legally. But I think, and so I think that's important to keep in mind. If something is a qualification standard under the ADA, you really have two legal obligations. One, you have to make sure that qualification standard is job related and consistent with business necessity for the specific job, not some general job. So you can't say, well, generally speaking, operators need to lift 70 pounds. So I'm going to have a qualification standard. Anyone who applies to my operator roles needs to lift 70 pounds. If your specific job doesn't require lifting of 70 pounds, you can't have that qualification standard because it's not job related for your specific job. The other key thing to keep in mind here is that even if you do have a qualification standard that is job related, meaning it's valid, you really do need this in order for this work to be done, you still have to consider whether an individual with a disability can meet the standard with reasonable accommodation. So let's go to the next slide, and I just want to walk through a case that I have just been this case is a must read, I think, for anyone who's like really interested in this issue. You can find some snippets of information about it online. You don't actually have to read the complaint or anything like that. It's this United States versus York County, South Carolina case. Recent case. It's brought by the Department of Justice. It was a settlement, so there was not actually a finding. But how this is a really good example of how you could be using qualification standards and not even realizing it. So this government county in South Carolina was hiring for a purchasing manager role, and they had a requirement that you needed a valid driver's license in order to apply for the role. An individual with dwarfism wanted to apply for the role. He did not have a valid driver's license and could not obtain one because of his medical condition. But he met all of the other requirements. He met all the education and work experience requirements. He tried to apply online for the position, the purchasing manager position, and he could not because there was a pre-screening question that asked whether you had a valid driver's license. And when he answered no, he immediately was sent an email, "Thank you for applying. You are not qualified for this position." So he contacted the county and asked whether an accommodation could be made. And they told him no. This was a mandatory requirement. Everyone, we need a valid driver's license. You must have a valid driver's license in order to be a purchasing manager here. He brought a claim, first with EEOC. It was then referred to the Department of Justice since it involves the state government. And the Department of Justice sued on his behalf. And they took the position, I think rightfully so, based on the facts I know, so I don't know all of the facts in fairness to the employer, that you did not need a valid driver's license in order to meet the essential functions of a purchasing manager role. While you may need to go to offsite meetings as a purchasing manager, there were other ways the individual could have gotten to those meetings, right? They could have used Uber or Lyft. If they wanted to, they could have used public transportation. And so the government took the position that the requirement to have a valid driver's license was a qualification standard. It was not job related and consistent with business necessity, and the county should have provided an accommodation upon request. They also took issue with the fact that there was a pre-screening question that basically screened the individual out when they answered no. And so this was settled. So, we don't know whether a court would have agreed with these arguments. But I think this case is a really good example of how all sorts of different parts of your organization could be impacting employment opportunities for individuals with disabilities without even realizing it. In particular here, I suspect that pre-screening question was created by talent acquisition. It very well may have been a requirement in the job description, but perhaps it hadn't been evaluated in a long time and no one had stepped back to think, do we really need a driver's license, or what is the task that we actually need done in the job, and could we accomplish that task, or could someone accomplish that task without a driver's license? So my tip to you in this area is, without a doubt, take a minute, think about whether you have mental and physical job qualifications, and then now is a good time, especially during COVID, when we're all reevaluating how work is going to get done, and kind of being more creative, right, about how work is going to get done, to think about whether these kinds of requirements where you're literally, a no answer means the person can't go any further in your employment process. Think about whether they're still valid and job related right now. So I want to wrap up with just 2 slides. These are kind of your action items, and I do appreciate you hanging in there. One other thing I want to point out here is we've heard the government already talk about the fact that they are concerned about the impact the pandemic may have on protected groups. Not just individuals with disabilities, but also potentially older workers. There's been a lot of discussion about the impact the pandemic may have on working mothers and females. And so the government has already said loudly and clearly, we are going to be monitoring your personnel activity when we audit you, and the period of time covered by the pandemic is covered by our audit. So you want to do that yourself proactively. I can't emphasize enough the importance of taking another fresh look at your reasonable accommodations policies and processes. And most importantly, focusing on how do your employees know to request accommodation, and how long does it take for an accommodation request to be processed. Looking at those personnel processes and qualification standards, using some of the tips we talked about today, I think this is really important, and EEOC has spoken about this a little bit since the health pandemic. The answer you may have gave 6 months ago about whether a particular thing would work or not could be very different now, because we are all adjusting the way we work. And there's some really good guidance out there about how to evaluate these issues as you change the way you work. And then finally, on the next slide, tracing that life cycle of an individual with a disability. One of the things that I ask clients to do in our section as they're preparing for their Section 503 reviews, I identify an employee, an applicant who self-identified as disabled. And I ask that my contact to go back and just trace that person's employment for me. Does it seem typical of the employment of others who were hired at the same time in the same role? Are you surprised at where they are or where their pay is? I think it's really illuminating to actually take the time and try to do that life cycle tracing, because sometimes there's nothing better than 2 or 3 examples to bring home this point to a manager. This is why we're going to do something a little bit differently. And then I do want to really highlight and commend the OFCCP's best practices webpage. Wealth of information there. We talked about many of the best practices today, but they're continually adding to this website as they go through these reviews. And this is one of the first places I send clients. If you're interested in doing something different in this space, read what some other employers have done and what has been successful, because there are some terrific ideas on this best practices website. And with that, I'm going to stop and turn it back over to Catherine. I'm certainly happy to stay on and take questions, but I do realize we're running a little bit late because of our technical difficulties.
Thank you so much, Lynn. And thank you all for being here and putting up with some technical difficulties. So we will be sending you copies of these and the recording as soon as we finalize the captioning. Lynn, as always, it's been wonderful, and you have so much to add, and we really appreciate the fact that you've done that with us today.
Thank you so much for inviting me, and thank you all for taking the time today to join us. I really appreciate it. I do just want to take a moment to say thank you for what you do in your organizations. I know this has been challenging times for HR and compliance professionals, and so I just want to give a huge shout out to all of you. I know you're working hard every day. You're the conscience of your organizations in many cases if you're in compliance. And so I really appreciate everything you're doing and taking the time today to join us.
Okay, thank you very much.
Bye, everyone.
Bye-bye.